Hello, legal eagles. Welcome to SQE1. I hope by this time you can fly very high in the sky to understand dispute resolution in England and Wales. I hope it makes sense. Once again, I would say, in order to get a very good grasp of everything, wave the story around a fictional character or something you understand that went through, you have an experience of, and you will understand how it starts. Like the someone has lost right, contractual or tort. At that point, they start the journey, and you just go through it, and it will help you understand the process, dates, and everything. So I hope our legal eagle can fly very high. And in this session, we will look at enforcement of judgment. That's kind of concluding session of our dispute resolution discussion. So today we are diving into enforcement of judgment. You might think that winning a case is the end of story and the money will be delivered in a packet at your home. No. But in reality, that's different. That's just the beginning. The court does not chase your debtor for you. That's your job as the judgment creditor, and they are judgment debtors. Think of it like lending your maid a teapot. Just because you ask nicely doesn't mean they should return it. Without a gentle nudge or a formal summons, they won't, of course, if it is very good and costly sometimes. But not all the people. Some people they return it. People are nice. Judgment and orders are generally enforceable for up to 6 years from the date they are made, unless you get special permission from the court to extend that period. So keep your calendar marked. 6 years can feel like a long time, but debts have a habit of sneaking past the statute of limitation or status of limitation at some point. So there is interest on judgment debts. Of course, there is interest is the law's way of saying thank you for your patience, but it's not quite that simple. In the county court, interest only applies if your judgment is 5,000 or more, or if it qualifies as a commercial debt under the Late Payment of Commercial Debt Act. High Court judgment, everyone invited. Interest applies across the board. Currently, the default rate is 8% per annum. So not only does the debtor owe you the original sum, they also owe you a little extra for making you wait. Think of it as icing on a very overdue cake. And yes, if the court orders a different rate, you have negotiated something special that will prevail. So, of course, you get your money. If it is late, you get interest on the top of it. Sometimes enforcing a judgment means changing the stage. This is called a transfer of proceeding. Some transfers are mandatory. For instance, county court judgment above 5,000 must move to High Court. Conversely, small debts below £600 or certain High Court cases may transfer back to County Court. Optional transfer exists here. If your County Court judgment is above £600 and not covered by Consumer Credit Act, you may choose the High Court for more robust enforcement. It's a big court, of course. And remember, enforcement usually happens near the debtor. The law does not expect you to track across the country. Think of it as beginning the theater closer to your unwilling actor. Convenience is key. So that's what you need to understand once you are going for enforcement of your judgment. So that's what it is. I have already explained it, so it county courts to high court to county court, and transfer to debtor's home place as well. So how to obtain information? Before you rush with enforcement, it is wise to gather intel, all intelligence, act like a spy. Why has not the debtor paid? That's what you need to look at. So number 2, do they even have the means to pay? There are 3 main ways to find. You can ask the debtor directly, hello, do you have money to pay me? Hire a tracing agent or apply for an information hearing through court. An information hearing allows the debtor to be questioned about their assets and financial situation. Proper information ensures you don't waste time chasing empty pockets. Because, let's face it, no one likes a wild goose chase. That's what you need to keep in mind. And the person must have some money to give you, otherwise, you can't recover until they got the money that they owe you. So, at an information hearing, individuals that are fill out Form N316 while corporate entities N316A. The debtor must attend court, answer questions honestly, and provide details about assets. Failure to attend or answer can lead to a commercial order, which is essentially a stern warning from the court. Think of it as destination for the financially delinquent. If the failure is unintentional, the court may suspend the order, giving them another chance, but repeated failure will likely trigger full enforcement action. This hearing is a crucial first step in understanding whether enforcement will be straightforward or a bit of a battlefield. So, what they do once to honor the enforcement at that point. So the first thing is taking control of goods of judgment debtor. If talking and questioning don't work, the next step is taking control of goods. In the High Court, this is done via writ of control. In County Court, a warrant of control. So High Court, writ, and County Court, warrant. That's what you should keep in mind. Enforcement officer can enter the debtor's premise, seize goods, and sell them to recover your debt. However, not everything is fair game. Essentials like clothing, bedding, household equipment, disabled badges, and assistance dogs are protected. You can't take away those things. At least let the poor person survive. Debtors must receive at least 7 clear days' notice before enforcement unless the court permits otherwise. Think of it as reclaiming your tea set, but with very specific rules on with items are off limits. So you cannot go to your friend and snatch your teapot back. No, it does not work like this. So another thing is attachment of earning. Another tool is you attach their earning. This deducts a portion of debtor's salary directly from their employer and pays it to you. It only works if the debtor is employed and debt exceeds £50. It will be, of course, more than £50. The court calculates two rates, the normal deduction rate and the protected earning rate. The debtor must still retain enough income to survive. Once granted, interest stops accruing, and you usually cannot use other enforcement methods without court's permission. Form N337 starts the process with additional forms N55 and N56 gathering detail of the debtor's financial position. It's a bit like setting up a direct debit, except with legal teeth. And another thing is third-party debt orders. Third-party debt orders target money owed to a debtor by someone else. For instance, funds in a bank account, loan repayment, or rent. The order directs the third party to pay the judgment creditor instead. Don't pay the debtor, pay to creditor. Debtors must be solvent and debt must be over £50 only. Special rules apply for bank accounts. Joint account cannot be targeted and balances cannot be reduced below £1. Form N349 is used to apply, and the order can be made without notice. This method is great when your debtor have money elsewhere but refuses to pay you directly, hides money somewhere. So another thing is charging order, and that gives you a security interest over the debtor's property. For example, land or securities does not mean you get paid immediately, but it ensures you have a claim if the property is sold. So you will be the one who will be getting the money out of it. Only debts over £1,000 qualify for charging order. Applications use like Form N379 and involve two stages. An interim charging order and final charging order. The court consider the debtor's circumstances and potential impact on other creditors. Because a person who owes you money may owe to other people as well. If granted, you can eventually apply for an order of sale. Think of this as putting a legal padlock on the debtor's property until they settle the score with you, give you your money back. So, other enforcement methods are, there are some niche methods like sequestration involves taking control of debtor's property if they are in contempt. Judgment summons can threaten imprisonment if payment isn't made. Bankruptcy winding up, it can happen, or debt relief order can also be used. But these are generally last resorts. Unsecured creditors may get little to nothing, and enforcement can be trickier. Always consider these as a polite nudge rather than your first move. No one likes being forced into court drama if it can be avoided. So, foreign judgment is a big thing. Yeah, that's what you need to understand. England and Wales can enforce foreign judgments too. In Commonwealth countries, you usually register the judgment within 6 years of county court judgment and 12 months of high court judgment. European and non-EU countries have separate regimes depending on when the claim started. Essentially, if your debtor had assets abroad, it's possible to pursue them there. Just make sure you understand the local rules. It's like sending a polite international courier to correct what's rightfully yours. Just get it back, collect it back. So to talk about something about practical tips. So what we have learned, enforcement is about strategy. Gather your information, use the right method for the right debt, and always follow the rules. Don't go to their door and knock it. Give me my money. I won against you. Common methods includes taking control of goods, attachment of earning, third-party debts order, and charging orders. Always remember, some items are off limit. Debtors' right matter, and procedures must be followed. Keep record, use forms correctly, and remember, patience and precision often recovers more than brute force. And if all these fail, a gentle reminder that the law has many clever ways to make debtor pay up. I hope it makes sense. Even it is of course it was overwhelming for me as well. Dispute resolution is not an easy task. It is a bit tricky, but with the right strategy you can understand it and you can crack it. I wish you all the best with dispute resolution. With this last video, I would say ta-ra.